Good afternoon, and thank you for attending today's webinar, Who are your business associates and what are your responsibilities as a covered entity, presented by Fernando Sosa of WorryFreeMD.com. Please be aware that there will be a question-and-answer portion today at the end of the webinar. To avoid frequent interruptions during the webinar, please type your questions in the question box located on the right of your screen. They will be answered in the order received during the question-and-answer portion. Additionally, an electronic version of this presentation will be emailed to all participants following completion of today's webinar. Again, NJMGMA would like to thank you for attending, and I will now turn things over to Fernando.
Okay, thank you, Dawn. All right, so let's get started. So as Dawn said, my name is Fernando Sosa. I am the managing partner of HeyOnTech.com. I'm a certified HIPAA security professional, Microsoft technology specialist, a Microsoft partner, project manager. I basically help small businesses make the most of their information technology resources. We provide computer maintenance and network support for private practices in New Jersey and Greater New York. HeyOnTech is the name of the company. WorryFreeMD is the name of our healthcare IT services. Okay, so here's our agenda for today. So who are your business associates and what are your responsibilities as a covered entity? So a couple of things that we're going to cover. First, I'm going to start talking about a little bit of a HIPAA background, not too much, just high level. Then we're going to get into covered entities, then business associates, business associate agreements, what are they, BAA liabilities, summary, next steps, and then we're going to get into a Q&A. So as Don mentioned, if you have questions, go ahead and type them, and we'll get to them at the end. Okay, so before I start, just a small disclaimer. HIPAA is a law, but this webinar is for information and educational purposes. I'm not a lawyer, so this is not legal advice. It's intended for to be used as a guidance. For legal advice, please consult with an attorney. Okay, so let's start. Now, HIPAA, as you all may know, Health Insurance Portability and Accountability Act. It was enacted in 1996. It is a federal law. Okay, I don't hear the term federal law a lot. I just hear a lot of HIPAA, but I like to mention it and underline it and bold it. It's a federal law, okay? And so it provides the baseline for privacy and security standards. But initially, it was enacted. It was really for to help patients have the continued health care coverage when they switch companies, when they switch employers. And then later on, it was expanded into what we know today. So the U.S. Department of Health and Human Services is the agency in charge of creating the rules that implement HIPAA and also enforcing it through OCR, which is Office of Civil Rights. So this was in 1996. So then in 2003, the privacy and security rule was established, and also the enforcement rule. The enforcement rule is another one of these things that I don't hear a lot, but it's also was a part of the 2003 revisions. And the privacy rule mainly has to do with protecting the confidentiality of the PHI. Security rule gets more into the technology and the electronic portion of it. The enforcement rule is more in use by the Office of Civil Rights, and they use this rule to manage the compliance, the violations, the penalties. These are all detailed in the enforcement rule. So it's okay for the providers and BAs not to really learn too much about the enforcement rule, but they'll learn about that if something happens. That's where it comes from, the enforcement rule. So usually when you take a HIPAA training, you'll learn about the privacy and the security rule, very little about the enforcement rule. But anyway, this is just some background information. This was in 2003, right? So fast forward a little bit to 2009. The landscape of technology, the medical field changed with the technology, and there was a shift to electronic medical records. So with the HITECH Act in 2009, that created a lot of financial incentives for providers to move to electronic medical records and address. So it also addressed the privacy and security concern and what we know today. So that happened with the HITECH Act of 2009, right? So fast forward a couple of years later, which what we know now is the Omnibus Rule, which is in 2013. Now, here is where a lot of the changes happen that affect business associates and the definition of business associates and how many businesses are now considered business associates and such. So there was a lot of changes done here with the rules, and a lot of the provisions of the HITECH Act were implemented with this rule, and also the breach notification rule was finalized. So that was in 2013. So just an overview again. 1996, you got the HIPAA was enacted. In 2003, the Privacy and Security Rule. 2009, the HITECH Act. And 2013, the Omnibus Rule. So this is nothing new. It's just an evolution of how HIPAA has evolved and what we have today, and it's still changing, right? So what does this mean? Who must comply with HIPAA? Now, one thing that it catches by surprise to a lot of people is that HIPAA is a federal law, but it doesn't apply to all businesses. It's not doesn't apply to all businesses. It only applies to covered entities and to business associates. So I often hear people think that because they go to a certain business and they see medical information that it's protected by HIPAA, and in reality that is not the case. So there are other laws that protect health information, but it's not HIPAA. So in terms of talking about HIPAA, this only applies to covered entities and business associates. Okay, so just to give you an example of another law that is not HIPAA, like for example, there's something called FERPA, which has to do with health information in schools. So even though the other businesses may not be compliant with HIPAA, they don't fall under these two categories, there is an assumption that the health information is protected, but it's not going to be by HIPAA. So this is just some clarification here. Now, what is a covered entity? Covered entities fall by definition under these three categories. So we got the healthcare provider. Those are the doctors, clinics, dentists, chiropractor, etc. Take care of patients, right? Those are the obvious ones. Then you got the health plans, which are the health insurance companies, HMOs, Medicare, etc. Right? And you got the healthcare clearinghouses. So these are entities that transfer non-standard information back and forth. So if a business is not in one of these groups, then they're not a covered entity. So then we have to ask the question, are they a business associate? So who are your business associate? So after the Omnibus Rule, the definition was expanded, and it's basically any person or entity who creates, these are the keywords, creates, receives, maintains, this one was a big one, the maintains or transmits PHI in the course of performing services on behalf of a covered entity. So basically, any business that has access to PHI on behalf of a covered entity is now considered a business associate. So this definition is regardless if you have an agreement with them. So if they're doing business with you, you're doing business with a company, and they fall into this definition, even if they're not into agreement as a business associate, they are considered an associate. So they are. So the implications of and the liability that comes into play and the requirements are still in place, even though there's not an agreement in place. So that's something we'll talk about a little further down. So an examples, I have a list here of examples, not a complete list, but an example of companies that are or can be business associates. We are consultants, management, building companies, coding, transcription, even marketing companies, IT companies for sure, data storage, etc. So the last one I have on the list is our subcontractors. So the key thing is if they create, receive, maintain PHI on behalf of covered entities, they are business associates. Now the subcontractors also fall into the category of business associate if they have access to PHI on behalf of the business associate. So it goes downstream, it goes upstream. So many vendors that you have may be business associates, and they may have subcontractors. And if those subcontractors have access to PHI, then those subcontractors are business associates of your business associates. And then everybody down this list, down the stream from covered entity to business associate to subcontractor business associate, they all fall under HIPAA compliance. They all have to be HIPAA compliant. So that's important to understand. Now, you know, and some vendors, I mean, you have to make really an inventory of all the vendors that you do business with and determine if they are or not business associates. And if they are, then you got to get into at least having an agreement in place and make sure that they are being HIPAA compliant. And we'll get into that in the next couple of slides. Some companies, it's important to understand, some vendors do business with other industries that are not healthcare specific. So they might do business with healthcare providers, but they also do business with other types of businesses that are not healthcare providers. So they might not have business associates in place, and they do business with you, but you as a covered entity need to have a business associate agreement with these business associates. Even if they do business with other businesses, under your responsibility as a covered entity is to have this agreement in place. And if you are a business associate on this webinar, and you do business with healthcare providers, you have to have this agreement in place as well, and with the covered entity as well as with your subcontractors that have access to PHI. And some companies might not think of business associates like marketing companies or data destruction companies, like for example, shredding companies. You hire a company to shred paper documents with medical records, insurance claims, and paper that you want to shred. If you have a company doing that, that is a business associate, and you have to have an agreement in place with them. So that's very, very important. Okay, so let's move on. If the business that you're doing, if you're working with is not a business associate, you still should have at least a confidentiality agreement. It's because you want to make sure that it's not assumed. You want to have a document that protects the privacy of your patient information. So if the business doesn't have access to PHI, but it's not a business associate, you still are better. It's recommended that you have at least a confidentiality agreement in place. If they are a business associate, then you definitely want to have a business associate agreement. Okay? Because sometimes some vendors might not be business associates, but they might have some incidental access to PHI, and you want to make sure that that they keep it private, that it's confidential, that they know about it. Just an example, like if you have a cleaning company might come to the office. They clean the office. They don't have access to PHI. Their work they have no need for that. However, if you have paper laying around with a PHI, a form or any document, and they're cleaning and they have access to it, or it's in a trash can, is not disposed properly, that's a privacy issue on your end. But they might have an incidental access to some PHI. They're still not considered a business associate because of that. That's incidental. But at least you want to make sure that you have a confidentiality agreement with them, just so they know that anything that they see is confidential. So these two documents, you should have it signed, and you hand it over to your privacy officer, which is a requirement that you need to have an officer. Because when it comes time to an audit or a breach or an investigation, it's all about documentation. Documentation, documentation, documentation. You want to have your ducks in a row, have everything documented, and this is one key element that you want to have in place, your agreement. Okay? So, as I mentioned, you have the covered entity, you have the business associates, and you have the subcontractors. They all face the same criminal and civil liability as covered entities, so it goes up and downstream. They all fall under HIPAA guidelines, so they have the same obligations. that covered entities has, and they have to follow the security and the privacy rules. Okay, so one example of a business associate or a vendors, with the new regulations in the omnibus rule, that it mentions that even if the company doesn't have any rights to access or view the PHI, if they're maintaining it, like for example, a company that stores information, if they have that information stored on their servers on their side, they are a business associate. Now with the advent of cloud computing, there's a lot of cloud EMRs, cloud backup, file storage, your email provider, etc. There's a lot of information in the cloud. These companies that have data stored for you, whether it's a backup or just a file storage or like a file syncing, there's a lot of file syncing services, and your email providers, they are business associates if they have information that has PHI. And for that reason, you need to have a business associate agreement with them to make sure that they are following HIPAA guidelines, they're compliant, and that they're protecting the patient information that is stored on their end. Now, what happens that many providers and business associates also use a lot of these vendors that are cloud backups or email providers that are free or low cost, and those types of services will not sign a business associate agreement with you, especially the free email services. There's many reasons not to use them for business, but this is one of them. You will not get a business associate agreement with a free email provider. You have to switch over to a higher tier or paid service to get that type of compliance. So it's very important for you to have this in place and understand that it's your responsibility to have these agreements in place with the vendors that are your business associates. And it might come to a point where you're going to have to decide whether you continue the relationship with the vendors or the service if they're not compliant. Because if you don't have the agreement in place, there's no agreement, there's no guarantee on their end that they are being HIPAA compliant. And you may make the assumption that the information that they have doesn't have any PHI. Like for example, email, you might say, oh, I don't have PHI in my email, even though I'm using a Hotmail or a Yahoo account. Well, you have to understand PHI is more than just medical record, number, date of birth. PHI, there's a lot of identifiers that define what is protected health information. It's not just the date of birth, it's not just the name. There are bits and pieces of information that is considered PHI. So you may not see, for example, a medical record or birthday or something that you think it's obvious PHI, but you may have bits and pieces of PHI stored in email, and that is a problem. So that's very important for you to understand that PHI there's many components to PHI, and you can have it in one of these outsourced companies. The shredding company, I gave you the example. If you have a shredding company that's shredding documents, you have to have a BA agreement with them as well. Okay, so liability for actions of business associate. Now, as I mentioned, the business associate have pretty much the same liabilities as the covered entities. They don't have all the requirements in terms of the privacy rule as a covered entity, but definitely all of the security rules. So it's some privacy, and all the security rules. So any violation provision of the HIPAA security rule is a liability. Now, uses and disclosure of PHI that don't comply with your agreement. So between you, a covered entity, and a BA, you agree to use the patient information in a certain way. If a PHI comes disclosed outside of that agreement, then that's a liability. Failing to enter into the agreement with the contractors, that's a problem there. Failing to make reasonable efforts to provide, to limit PHI to minimum necessary is a problem. Minimum necessary is important also to understand because I see this over and over. If you have staff, whether you are a covered entity or a BA, you don't give carte blanche access to PHI to everybody just because they work for you. You have to comply with what's called minimum necessary. And that what that means is that you have to give access to PHI to your staff as little as possible, only what they need to know. It's only a need to know basis. So if their job description, their job function doesn't require access to everything, you don't give them access to everything. You just give them whatever they need to accomplish the task. And so you have to make a reasonable effort to limit PHI to minimum necessary. So that's a big requirement for both covered entities and business associate. And of course, if there's an investigation, you know, you have to disclose the PHI. This is where the audit trail comes into play, where you have to provide information to HHS for the investigation to take place. It's kind of similar to an IRS audit, where you know you're being audited, you have to provide a whole bunch of records, and it's the same thing. You have to, if you don't have those records, then that's a liability, that's a problem. And so as part of the security rule, you know, you have to implement administrative, technical, and physical safeguards to protect the integrity and confidentiality of PHI. So that implies establishing controls, access controls, firewall, virus protection, encryption, policies and procedures, etc. So it's a lot of work, right? Now, all of these requirements to be HIPAA compliant for a business associate can be a significant challenge for many BAs, even for small covered entities. You know, some people might say that being compliant is easy. It could be challenging to be compliant. And you know, for example, one of the minimum requirements, or one of the first steps to be compliant, is to have a comprehensive HIPAA risk analysis done. Now, risk analysis, you hear of risk security analysis, security assessment, HIPAA. We're talking about the same thing. However, not all of them are done in the same way. It's a requirement that all business associates and covered entities do annual HIPAA risk analysis every year. It's a requirement. And with that risk assessment, the problem is that HIPAA doesn't give you exact implementation details on how to do the risk analysis. They give you guidelines and provide you some questions, and it's a guideline. But it's because it's a guideline, many companies might not have the same level of detail in the risk assessment. And if you go back and check the history of breaches that have been reported, you will notice a trail that indicates that many breaches occur because of a inappropriate risk analysis done. So it's not because they didn't do the risk analysis, but it's because it wasn't it was inadequate. And you can go and check that, and you'll see on the press releases that they'll say that. So it's important. So as you can see, for a business associate, this might be a little challenging if you're doing a self-assessment or if you're not outsourcing it and getting a comprehensive security risk assessment done. So the HIPAA police. Now, Office of Civil Rights that's what typically people call I hear called HIPAA police, because this is the office that enforces HIPAA. And they basically start with an investigation, and the investigation starts either by a complaint or a breach, right? So a complaint, anybody can file a complaint. They just go to the HHS website, like you see here, and they click on a link and they file a complaint against you. It's that simple. As consumers, as patients start learning more and more about this is not new, but over time it becomes more and more common that, you know, any patient can go to a website and file a complaint against you, or it could be a disgruntled, even you know, it could be. Listen, if that link is there and it's a public site that they can file a complaint, it'll start an investigation, okay? And once that starts, then you know, you're contacted to provide some information. They'll ask you questions. Probably the first one of the first things will be the risk analysis and see if that's done. Obviously, if there's a breach, that triggers an investigation as well. Big audit trail has to be checked on that. So, you know, this is what Office of Civil Rights does, and they basically follow the enforcement rule to do this. So, how does HHS determine a penalty for violation? Okay, so take a look at this. There's basically four types of violations. So we have the unknowing violation. Now, the unknowing violations are the violations that covered entities did not know, and they couldn't have known through, even if they did their due diligence. It's just they just didn't know about it. Okay, so that's the minimum one. It starts at $100 per violation. Reasonable cause. Okay, this means that you should have known about this. If you did your due diligence, you did your risk analysis, you should have known about this. But you didn't. And so then, as you can see, the penalty is higher. And willful neglect is the worst case. And basically, that's negligence. Willful neglect, it's just reckless. It shouldn't happen. And there's two types. There's corrected and not corrected. Corrected means that you correct the issue after it's discovered, usually within 30 days. And not corrected is just, you know, just whatever. You just forget about it. Don't fix it. Those are the ones that have the higher penalties per violation. So, you know, willful neglect is that, you know, you saw something, you just didn't fix it. You knew about it. It's on your risk analysis. You just didn't fix it. So those are the types of violations. And as you can see, this can get very, very expensive. And this is per violation. What this means is that one breach, a single breach, can result in numerous violations. So this number that these numbers, you have to multiply by the number of violations. So for example, a laptop that gets lost and has hundreds of PHI, of patients' PHI, that constitutes hundreds of violations. So that's how the numbers add up. Just imagine that. You know, 100 patient records, 500 patient records, or, you know, and multiply by these numbers. Very, very expensive. So it's an example of a violation. Another violation I have here, each day that a covered entity or an associate fails to implement a policy constitutes a separate violation. So each day is considered a violation. So that's an example, right? So as you can see, again, you know, these are just in penalties and violations, but there's other costs associated if there's a breach, right? It's not just a violation cost. So here's a surprise. A covered entity may be a business associate for another covered entity. So how does that work? A covered entity can be a business associate for another covered entity. Well, that can happen, and you need to know that if you are a covered entity and you are also a business associate but you don't know about it. Well, when are you a covered entity and a business associate? Well, for example, let's say an example, a provider hires another provider to do a training or a class, something that is not necessarily taking care of a patient. They're both covered entities, but the business relationship is not that of taking care of a patient. It's a different relationship, but they're both covered entities, but one is acting as a business associate for another covered entity. So in that case, there has to be a BAA in place. Okay, so that's, you know, also it could be easily overlooked and assume that because they're both covered entities, they have, you know, they can do carte blanche anything with PHI, but It all depends on what the relationship is. If it's two covered entities treating a patient, that's different. They're both covered entities, and they're not BAAs to each other. Okay, so that's something good to know for covered entities. Now, another important thing here that I don't hear often: your business associate acting as an agent. Okay, one of the key things here, if you have a business associate agreement and you have certain control or certain detail in the agreement that gives you control over the associate under the federal common law of agency, they are considered an agent. And if the business associate is considered an agent of yours, then the liability falls back onto you. So you want to try to, as a covered entity, you want to try to minimize or prevent business associates acting as an agent, unless it's necessary for whatever reason. But you definitely want to be aware of this, that just because you have an agreement in place, the wording on the agreement, the detail of it, can determine if the associate is acting as an agent, and therefore what you're looking for in terms of protection is not going to be there. It has to do with the authority. If you have control over the conduct of the agent, of the associate, if you try to control the details of how they're going to do their work, where they're going to do the work, that sort of thing, that makes them into an agent. So this is what's determined as a federal common law of agency I have here. So basically, this eliminates the current exception excusing covered entities for liability based on actions of their agents who are business associates. So important to understand here is that this is a case-by-case thing. If something happens that it goes to court, there's no clear-cut definition or guideline that says this is an agent or this is not an agent. If it comes down to a lawsuit or something, it's a fact-specific inquiry, and they'll hash it out in court. But you want to minimize your agreements to be general in terms of how they're going to perform the duties that they're going to perform. So, for example, you want to have the language that is general, and I'm going to get into that in the next slide. So how do you avoid this liability? Well, like I mentioned, you want to avoid BA acting as agents if possible, because sometimes you can't, just the relationship that you have, you can't avoid it. Or if you have a staff that's it's a contractor, but it's you have certain control over it, you just can't avoid it. But you definitely want to be aware of this. So the BAA, Business Associate Agreement, must not specify how they will provide service, except in general terms. Okay, so that's what I was saying. So the agreement doesn't exercise any right to control the behavior, even if it does not initially do so. Okay, so this is very, very important, and this goes unnoticed a lot, especially when the agreements are being drafted and the covered entity wants to have more and more added to the agreement, and they fall into this trap that they're acting as agents, just because they're detailing too much, they're giving too much detail and want to know too much about how they're going to do these, do what they need to do. So, for example, a shredding service, you have a BAA with a shredding company. The language, I have in quotes here, it says, in a manner that preserves confidentiality. So it doesn't give you details how exactly. It doesn't say what kind of a machine they're going to use to shred. It doesn't say at what time of the day they're going to shred. It doesn't say where they're going to put the shreds. It doesn't say what clothes are they going to wear, or the details. It does not matter. That's something that you would do if you employ the person as an employee or as an agent. So that's what you want to avoid. Another thing that you want to do is you want to review whether insurance covers HIPAA liability by business associates. And you want to have cyber liability coverage. So this is very important because you want to estimate, it's insurance. You never know when you're going to need it, but when you need it, it's good to have. So if you have a breach and it's going to cost you a lot of money, you don't know exactly how much, but you want to have some type of coverage, and you can call it your breach insurance. If you need to pay money in penalties, you want to have some type of coverage. And just so you know, just to get a cyber liability insurance coverage, a lot of the companies providing this type of coverage, they're going to require that you have certain things in place in order to have this type of coverage. You can't just buy an insurance and coverage for cyber liability without having certain security measures in place. Okay, so you'll see that once you reach out and try to purchase one of these. So, but you definitely want to have that, and it's also good to ask if your associates, if your BAs have that type of insurance, because at the end of the day, if something happens, you want to make sure that everybody protects the information in the best possible way, and that they're covered as much as possible. So that's something important to have in mind. Now, the final rule clarifies that any person, regarding they have entered into an agreement or not, if they have access to PHI, then they are a business associate. So covered entities, they're not required to enter into a direct contract with the subcontractors of its BAs. Okay, so that's between the direct contact. So it's covered entities, business associates, and then subcontractors. The subcontractors and the covered entity don't need to enter into an agreement. Okay, but you want to get into the agreement with the direct contact, the direct vendor. So it's very important with that. So how can the violations of a business associate affect you? So it can affect you in many ways. It's not just about the money in terms of the violation and like I have here on the slide, your reputation is impacted. If you're a covered entity and you have a breach, it doesn't really matter. The patients, the general public doesn't really care what business associate. At the end of the day, it's your patient, it's your business, and you are going to be put on what's called the wall of shame. I'll give you a screenshot of that next. Every breach that has over 500 records is put on this public website by HHS, and you're basically listed there as as having a breach. And if it's your business associate, your name your company name as a covered entity still shows up there. So that's bad PR. So that affects you in a bad way. Notification costs, obviously that is very costly. If the breach, you have to notify patients. In some cases, you have to notify the media, and that's very costly. It also affects your relationship with current and prospective patients and policyholders and beneficiaries, right? If you have a breach, that's not good for your record, right? The current patients might decide, to go elsewhere, and it can also lead to an investigation. If the business associate has a breach, it can lead to an investigation for you as a covered entity. So again, it's not something that you want. Okay, so these are some things that affect you in a negative way. Now, how to avoid. Now, here's an example of the wall of shame. You can go to, I can give you the link. If you don't see it there, just contact me. I'll give you the link. So one thing important to understand is as of early of 2015, approximately 1,100, almost 1,200 breaches reported in the HHS portal. But interesting is that business associates were reported as involved in only 273 of the breaches. So this is important for you to understand as covered entities. Breaches don't just happen at the business associate level. In fact, the majority happen at the covered entity level. And this is proof for that there on the public records there. So as a covered entity, you have a lot to protect in terms of privacy and security as well. So breach notification, ultimately, you want to notify your patients. You don't want a third party to notify your patients, even if they had the breach. So that's something that you have to think about in terms of notifying if something happens. And one last thing here is it's the law. Like I started the webinar, HIPAA is a law, folks. There's no reason for willful neglect, and it's not a new law. Business agreements, it's a 13-year-old requirement. It has changed, yes, but it's an old requirement. Security risk analysis, 11-year-old requirement. If you've never done a risk analysis, it's not new. The enforcement, however, started ramping up 4 years ago, okay? And it's getting more and more. You're going to see more and more audits as time goes on. So the thing is that previously it was a voluntary compliance framework. There was no teeth into it. We're not enforcing it. But that changed. So now it's penalty-based. So you really want to get your ducks in a row and address this as a covered entity and as a business associate. So what are your next steps? Identify your business associates. Make a list. Look at your invoices and just make a list. Who are you doing business with? And you want to identify if they are business associates. You want to check if you have an agreement in place with them. If they're old agreements, if they are agreements that were in place before 2013, before the omnibus rule, those need to be revised. If you don't have one, you have to sign new ones. Okay, so you have to do that. You want to review and update your policies and procedures. You need to have your mandatory HIPAA training. All of this information, if you have HIPAA training, can alleviate a lot of the concerns. HIPAA training is mandatory for your staff, for your workforce, and also for your security officers. You have to have your officer, your compliance officer in place as well, and has a little bit of a more extensive training done. That's mandatory. Insurance, you want to verify your insurance coverage to cover a breach. If you have a breach, you want to check your insurance. And lastly I have is you want to avoid self-assessments, because assessments, it's not just about having a checklist done. It's not just about being compliant and it's about being secure. And to be secure, you want to make sure you have a comprehensive risk assessment done where it covers not just on paper and makes it and checks off everything. You want to make sure that your network is secure. You have a physical on-site diagnostic check done, and that complements the rest of the questionnaire and everything else that you need to do in the assessment. So doing a self-assessment is very, it's an indicator that it's not going to be adequate if a breach happens or an investigation happens. So those are the steps that I have here. And so thank you very much. I'm going to open it up for Q&A. On this slide, I have Alex Kielski, which is the attorney that I consulted. Now, like I said, the webinar, this is not a legal advice. You want to contact your attorney for legal advice. So I'm open to questions now, Dawn. Is there anyone?
Okay, Fernando, thank you. Folks, if you have any questions, please type them in the question box. Apparently, you were pretty thorough, Fernando, because I don't see any questions at this point. We'll give them a couple seconds, and if not, we'll close the webinar out and get the presentations out to all the participants.
Okay.
Folks, we'll give it just a couple seconds here to see if any questions pop in, and if not, we're going to close the webinar down, and thank you again. Okay, doesn't look like we have any questions coming in. Fernando, thank you so much, and thank you everyone for attending. The presentations will be sent electronically by the end of today. Thank you all for attending.